Hi, this is Seth Rosenberg at the Seattle Litigation Group, and I'm here to talk about professional licensure defense. Many people don't understand what that means, and hopefully you never have to know. In essence, there are many different professions that are licensed through the state, and there are many different businesses that are licensed through the state as well. In fact, there are over 70 different professions licensed through the state, and those licenses come with terms and conditions. And if you violate one of those terms or conditions, or have alleged to have violated one of those terms or conditions, you may face charges from the state. And the process of how they charge you is relatively uniform. There is something called the Administrative Procedures Act, which is RCW 34.05, and that governs how the process operates. There are different permutations between some of the departments, but generally it follows the following pattern. A complaint will be lodged against you, which opens an investigation. An investigator will be assigned to look at your case. They will write you a letter telling you that a complaint has been filed against you, and then they will, generally speaking, write a second letter asking you to respond to the questions they have posed therein. Certain departments don't ask you for those questions, but most of them do. Some investigators will attempt to talk to you in person, but they generally don't have a right to interview you personally. At the point that you are contacted by the department, it behooves you to obtain an attorney. After you have responded to the department inquiries, they will make a decision about whether they're going to charge you or to dismiss the case. Oftentimes, in this case, there is an opportunity to settle the matter informally, and if a settlement can't be reached, then the statement of charges is issued, and you, the licensee, need to request a hearing. You should always request a hearing because it preserves your rights. There's a specific deadline by which you have to request that hearing, and if you miss it, you lose all your rights. So the best thing to do is to immediately request and then go about attempting to contact an attorney. And there's an important aspect of this, which is that the department generally needs to receive your request for a hearing by the deadline, and not just that you mail it. Even if you represent yourself, you will do better than what they are generally offering you in the statement of charges. Once you request a hearing, a presiding officer will be appointed. This is not actually an Article 3 constitutional judge. This is oftentimes an employee of the very department who's charging you, or alternatively, someone from the Office of Administrative Hearings. The process then follows what we would call the general civil litigation process towards a trial. There's discovery, including interrogatories, requests for production, and depositions. There's a motion practice, including motions to dismiss or what's called summary judgment. And then there's ultimately a hearing if it can't be resolved before then, or if the motions do not resolve it before then. And that hearing, although it's informal, still has all of the hallmarks of a normal civil litigation trial. There are witnesses, there's testimony, there's cross-examination, people are placed under oath. There are several differences. One is that hearsay is admissible, which means people can come in and talk about what other people purportedly said or did, even though those other people aren't there in court to verify that. There's generally lax rules as far as an admission of evidence in general, and then the presiding officer makes a determination. Another thing that is different from the civil litigation process is that the director of the department can, generally speaking, reverse the decision of the presiding officer. So even if you prevail at hearing, the department director can decide, in fact, that he doesn't want that decision to go forward, and he can reverse that decision and find you guilty. There are appeal processes up to the Superior Court and beyond, but generally speaking, the facts are set at hearing, and so it's best to have legal representation early on because it's very hard to appeal facts. Again, I would encourage people to contact attorneys as soon as they're notified, and not to speak to the investigator early on, because the investigators are there not to resolve the problem, but to build a case against you, and what you say to them cannot be undone. We are here to help 24 hours a day, 7 days a week. It's our primary practice area, and hopefully you'll never have to contact us. But if you do, we're here to help. Again, this is Seth Rosenberg at the Seattle Litigation Group.